Miami medical malpractice statistics. Medical errors account for approximately 10% of all deaths in the United States. That makes medical malpractice the third leading cause of death in the country after heart disease and cancer. What is the statute of limitations on medical malpractice in Florida? While personal injury cases involving negligence must be brought within 4 years, Florida medical malpractice cases are subject to a 2-year statute of limitations. This stricter procedure can be seen among a number of other states. Essentially, victims of medical malpractice must file a lawsuit within 2 years of knowing or being reasonably expected to know that they were injured. Additionally, Florida medical malpractice cases are also limited by a 4-year statute of repose. What this means is that healthcare providers cannot be sued for medical malpractice more than 4 years after the date of the incident. A few exceptions to this statute exist, namely cases in which fraud, concealment, or misrepresentation played a role. Victims of medical malpractice may find it difficult to seek legal representation for their case, particularly if they're in the midst of recovering from a misdiagnosis injury or other medical error. Some victims may even wonder if they have a case at all. To dispel the confusion, be sure to reach out to a medical malpractice attorney in Miami as quickly as possible after your injury or experience. A knowledgeable lawyer will be able to examine the facts of the case and determine whether or not you have a reasonable medical malpractice claim. How long does it take to settle a medical malpractice case? One of the first questions a medical malpractice victim seeking legal counsel might have is how long does it take to settle a medical malpractice case? The answer is that it depends entirely on the complexity of your case and what kind of settlement you'll be willing to accept. Some Florida medical malpractice cases can be settled in a matter of months, while others may go on for multiple years. Everything from the nature of your injury to the number of people involved in your care can have an effect on the length of your case. Identifying the at-fault party may also slow things down. For example, if you suffered complications after a surgery, the court will need to know exactly who was responsible. It could have been a doctor who botched the surgery, a nurse who delivered the wrong aftercare instructions, or a pharmacist who filled the wrong prescription. These types of cases can be costly, lengthy, and mentally taxing, particularly if you're recovering from your injury or continuing to suffer with a condition. Our experienced team of attorneys are here to help. If you have questions regarding medical malpractice, we encourage you to contact newfoundlawfirm.com today. We accept all cases on a contingency fee basis. That means if there's no recovery, you don't pay a cent. To learn more, please visit newfoundlawfirm.com.